Okay, well, I'm Marcia Getting, and I'm the one that seems to have trouble with technology. But I'm delighted to have you join us today to learn some information about trust, because that's what we're going to be talking about. And I'm ever so grateful for a co-host, Emily Stanley. She is a county extension agent located in Lewistown, and she works in Fergus and Petroleum counties. So Emily and I work together. I typically travel the state doing educational programs in the area of estate planning or whatever it is the county agents want me to do. And what I did is just go back, where Emily asked you to indicate where you were from. And I saw that we really have a nice spread of individuals. In some places, we have more than one. And we're just delighted to have you join us and see what you can learn about trust and the other topics we talk about. And today, for the first time, we are having some folks join us from AARP. They have been notified that they can attend these programs, and so we welcome you very much. And then we still do have a few out-of-staters that we're delighted to join us, and it's really great to have this method to share with individuals. Now, those that have attended before know that what I like to do is use polls, because what a poll will do is allow me to see and to sort of keep your interest in what we're doing. And the very first poll that Emily has brought up here is to just have you get the experience of using it and tell us what % of Americans age 50 to 64 do you think have a trust? And this trust could be a testamentary trust, it could be a living trust. What do you think? So while you're doing that, I'll let you know this is a research project that AARP had several years ago, just to give the sense of find out what people have and don't have. So they ask about wills, they ask about trusts and other kinds of things. So Emily, what have we got today with the response? Okay, we've got folks that are responding, and we see that only 4% think 69, and we go all the way up, and ta-da, you guys have got it right. It is exactly that 19%. So didn't fool you, but it shows how knowledgeable I've got. And one of the things that I noticed in the report is the percentage does tend to go up as we get older. And I think if we had a research project on that more recently, that we would find probably a higher percentage than 29 have one now. Now, the second enhancement tool that I utilize in my programs is wildflowers. I like to use wildflowers to trigger thoughts, trigger names, help you remember things in this program. And since we have some new folks, I just want to remind you that I think it'll work. And I want to make a disclaimer that the flowers that I'm using, I did not destroy. We didn't bring them back to a studio of any kind. We take our photographs when we're out. And this is one that I call my Yellowstone studio. You can see I use an umbrella there, and I'm always capturing flowers that I think might be a cute name that I could use. And one of those is a pine drop. And yes, I found this pine drop looked exactly like a question mark. And I told my husband, stop, I've got to take a photograph. But I use this as a trigger to remind you that if you have questions, put those in the chat room. And then also to let you know that Emily and I are going to hang out for another 30 minutes with you and be able to try to answer some of the questions that you might have. So be thinking of those. Now, this is my steer's head. And, if I was in Yellowstone Park this month, I would be able, and the park was open, I would be able to see this steer's head. They're beautiful, beautiful little flowers. But what they remind me of is my objective for today. And I want you to become a wise consumer when it comes to trust. Now, what I'm going to do is have a sugar bowl here to represent trust. And you might think, well, that's kind of weird, but it reminds me of when I was a kid growing up. And I noticed that my mom was putting money in a sugar bowl at the top of the kitchen cabinet. Now, yeah, I wasn't supposed to know that, but I thought it was really cool. And I always wondered what my mom would end up buying with it. And it was a vacuum sweeper. So I was less than excited. But our sugar bowl tells us about trust. And if we were a live audience, I would be asking you, what reasons have you heard on why people want to have a trust? And you've probably heard it's better than a will. And you may have heard it avoids probate, it avoids taxes, and all other kinds of things that are about trust. Now, there's some very good things about trust, but there's also some advantages and disadvantages, just like any other estate planning tool we've got. So first of all, what is a trust? A trust is a legal entity, and that legal entity is going to hold title to property for the benefit of one or more people. You could have several if you want to. And there's all kinds of trusts out there. There's revocable, there's irrevocable, there's special needs trusts for children that have challenges, let's say. And we've got AB or bypass trust, the charitable remainder. I mean, we could go on and on about the ones that are out there. But what I thought I would do is tell you about the two most common that we have, and that's revocable and testamentary. Now, one of the things that you'll need to decide is the name that you're going to use for the trust. And this example is just James Simon and Lois Simon. And they have named themselves as the trustees of the Simon Family Trust that was dated on March 20th, 2020. Okay. And when you've got a typical living trust, what you find is the trustees and the persons that put the money in, and under our new law in Montana, they're called settlers. But that's what they are. And it could be the husband and wife. It could be grandma and grandpa. They're the ones that are establishing the trust, and they're utilizing the trust assets for their own benefit initially. Now, your successor trustees are those that you name to take over. Now, we've talked about maybe a power of attorney, financial. Well, that does a similar type thing, but the successor trustee is the one that takes over and manages those assets that are in the trust. So that could be an adult child, could be a successor, maybe your adult grandchildren, maybe you've got a trusted friend, or maybe a corporate trustee. And if you're thinking about a corporate trustee, you really need to visit with them ahead of time, because I found in my research, there's some out there that won't accept a trust with assets less than $1 million. Now, that kind of puts you in the situation then if you're establishing a trust for the benefit of some of your grandchildren under age 18, and you want a corporate trustee and you only have 100,000 in there. Oops, that means Uncle George or Aunt Susie might be the one that you want to have as the trustee. Now, the beneficiaries, you have to decide that in ahead of time, and you decide if they're going to get income from the trust and then assets. And you can determine this at any age. You can do whatever it is you want to with the assets that are in your trust. If they're revocable living and they're done by the trustees and the settlers are the same, you're using that asset for your own benefit. But you've also then written in the trust agreement what kinds of things are going to happen after you die. And this trust agreement is, think of it similar as a will. You go through that same process. Who do you want to be as your beneficiaries? Do you want to treat them equally or equitably, like we talked about last week? What other kinds of directions do you want to put in your trust? And that could be very short or it could be very long. I once had an individual share that the trust that they have is 90 pages. And my goodness, that was a grandpa that was, let's just say, a little controlling because there were all these kinds of issues that he had in there. Now, if you're going to establish a revocable living trust, you have to change title of the assets that you have that you want to go into the trust. That's very, very important because a trust document cannot control items that aren't in the name of the trust. So what kinds of things can you place in there? Well, maybe you've got some land, you've got your home, a checking account, certificates of deposit, securities like stocks, bonds, and mutual funds. So all of those things that you want the trust to control have to be in that name, like Jim Simon and Lois Simon as trustees for the Simon Trust dated March 20th. So that's what you have to do. You have to transfer those assets into the trust. And I want to reemphasize that because we did have an instance of a disbarred attorney from North Dakota came across to eastern Montana, and he was going around to a lot of our farms and ranches, mostly ranches out that way, and telling them, oh, George down the road thought you might be interested in this. So he was charging them $1,800 for these pieces of paper that were considered as a trust. Well, then I got phone calls at my office for people that were wanting to know, well, what do I do now? They didn't even realize that they needed to put property into the name of the trust. So keep that in mind. So my reflection from the Sugar Bowl is don't really get bowled over with trust until you understand more about it. And that's what we're going to do for the rest of the session.
Marcia, can I
Yes.
interject really quick? We've had a couple folks ask some questions in the chat and Q&A about technical things with WebEx, and I'm trying to answer those, but for the folks who are doing that through the Q&A, I'm not able to send you more than one response until you ask me another question. So make sure that if I haven't answered your question, you keep asking it, or if you use the chat, it means that I can keep sending you messages even if you don't ask me a question. Just wanted to interject so I can make sure everybody can hear what they need to. Sorry about that, Marcia.
Oh, that's okay. I had no idea that you had to have a question before you could answer it again. You want to keep sending out messages. Okay. Well, we'll hope we get everybody on board. That is one of the challenges of this new technology. When it works, it's wonderful. And when it doesn't, it's so frustrating. You almost think you're not going to go back. But we want you to come back and learn. So let's take a look. This happens to be a Richardson geranium. And it's one that I'm quite proud of because I got out there right after a rainstorm, and you can see the little drops on it. So what I'm using this to represent is Granny Richardson. Now, Granny Richardson happens to have 5 grandchildren. And one of her goals has been, I want to treat my grandchildren equally. So what Granny Richardson did is she set up some assets. And she was a person that had attended one of my past estate planning programs. And she learned that you could put a transfer on death registration on her mutual funds. So she did that, one for Joe, Sue, and Rob. Then she's got some certificates of deposit. And what she decided to do with those is put them payable on death. Because if you have a payable on death or a TOD on your securities, it goes to those people without probate. So Granny is really excited. You know, she knows she can avoid probate. They're going to get the assets. Then she started getting in the reports. And if you take a look at those particular figures, you can see that, oh, Joe is going to be a little upset because he only has $10,000 that he would inherit. And we've got Tim that would receive $14,000. And Granny Richardson is saying, that's not what I want to have happen. You know, I thought this would be so simple and I keep changing. And she said, this is a hassle. There's got to be a better way to do this. So she visited with her attorney, and there is a better way. What can she do about this uneven distribution to her grandchildren? She was very clear this is what she wanted to accomplish. Equal, very equal. So one of the alternatives that the attorney recommended was a testamentary trust. In other words, this is a trust that has been established in Granny's will. It's a part of the will that says, upon my death, I want all of my assets to go into this trust and then be distributed. So what Granny has done is designated her testamentary trust as the beneficiary, not her grandchildren, but the trust. So if we look at the assets that Granny Richardson has, maybe she's got some insurance. So she has beneficiary designations on that, but it's to the trust. She has bank accounts. Okay, she's going to make it payable on death to the testamentary trust that she has. Same way with those mutual funds that originally were to go to the grandchildren. She has changed the beneficiary to be that testamentary trust. And then we have a new law in Montana that talks about real estate. So she could even have her real estate go by a transfer on death deed, and then that will go into the trust as well. And then if she has some retirement plans, everything is now in this testamentary trust. Then she puts in directions. Now, the other thing she added was a clause in the will. Let's say Granny forgot something. Maybe she bought a lot. Her and her husband bought a lot way back in 1950, and she just forgot about it. Well, in your will, you can put what is referred to as a pour over clause. In other words, if there's something that I forgot to have a beneficiary designation to the trust, I want it to pour over into the trust. Now, I got to admit, the first time I heard this pour over clause, I thought they meant POOR, and I couldn't quite get it. But I'm sure you do. It pours over into the trust. Now, there's a benefit to Granny to do this. Now she doesn't have to keep changing her beneficiary designations. She can even out those distributions to her grandchildren, and she's very thrilled about that. And the other thing is that her beneficiaries' creditors, these kids, and let's just say maybe they aren't as wise or financially astute as they need to be. Well, the creditors cannot come after the assets that are in that testamentary trust. So my reflection from Granny Richardson's Geranium is that a testamentary trust could be a useful tool for treating her grandchildren equally. Now here we have another favorite flower of mine. It's called an explorer's gentian. So what I want to do with you is explore some other uses for a testamentary trust. How about minor children? Let's say that you're a parent and you have young children. Well, if you were killed in an accident or got the coronavirus and died, who would you want to manage the assets? So you see, all of your assets could go into this trust for the benefit of those children. And the advantage there is that you could say they could receive the trust income for a certain number of years, and then they would get the whole amount, the total assets that are in there at a different age. But you see, if you don't have something like that and you just have a will and you leave the property to your minor children, there has to be a process called a conservatorship. In other words, not only are we going to have a guardian to take care of the kids, but we need to have a person that's going to manage the money for them. And you may have a financially incompetent heir. Now, that's a nice way of saying you've got a kid that maybe they just can't manage money. If they have $100 this week, it's gone by Saturday. It's just the way it goes. Or you may have a child or a grandchild or some other relative that does have addiction challenges, whether that be drugs, even gambling. It can be an addiction. So you want to have that money protected for that particular kid. And then this one became very real because of my mom's Alzheimer's. You may have a spouse or a parent that's really incapacitated. They can no longer make financial decisions. So a wise thing is to establish a trust so that those funds can be used for the benefit of that individual. So here we have a family, and we're looking at mom. And mom is the last one to die. So everybody that has a black box are deceased. So mom dies last. And what I'm going to do is ask you a question here pretty soon about the son. So we've got mom and dad, we've got 3 children. And this is going to be a question on what fraction, if any, does the surviving son receive? What fraction, if any? Is it nothing, 1/3, 1/7, or 1/9? What fraction of any does that son receive? I will say that mom dies without writing a will. She didn't get around to writing one. And that's something we could be thinking about right now. If we're spending more time at home and we're really running out of useful things to do, how about getting our notes together for writing a will and thinking about who we want to receive items? Okay, Emily, what do we got today with a response? Okay, we've got 9% that said nothing. We've got 35% that said a third, and 9 that said a seventh. And we have a lot of non-answers in there. So I hope you're answering that question in your brain. But here's the deal. I'm very glad I asked that question because only 9% of you got it correct. The answer is that son is not going to receive everything. What happens is everything is going to go from mom to dad here. Now, remember, dad has Alzheimer's. So we've got a challenge here. We've got to have a procedure in court, and we've got to name guardianship and conservatorship for dad because he is in the later stages of Alzheimer's. And we've got to think about who is going to initiate the proceedings, the surviving son, one of the adult children, the public administrator. And what are we going to do with dad? Where will he go? Can he stay by himself? Well, the answer is probably no. So do we think of some sort of nursing home is appropriate? Would he allow it? Can he afford it? There's just all kinds of issues looking at a situation like that. And I wish I could have sat down with the mom there and said, hey, do you know what's going to happen here if you die? And as a matter of fact, this is one of the situations that we're using in a mock guide that should be available within the next month to take 3 situations and look at alternatives. So let's explore some distribution standards. They can be discretionary or they can be mandatory. So discretionary is you're leaving it up to your trustee. You really, really trust this trustee and you say, hey, and that's what I'm going to do with you. You all that are attending today are a trustee, and you're to use my trust for the benefit of my nephew, Christopher. And the only direction that I've given to you is to say you need to use this for the health, education, and maintenance, plus support of my nephew, Christopher. Those are the directions in the trust agreement. Now, Christopher comes to you. You're the trustee. He wants to take a trip during the summer to Europe. And he says it will be a very educational experience. What's your response? You're the trustee. Will you provide funds for a trip to Europe from the trust? In other words, are you going to give Christopher that money? And Christopher's looking at you with those blue eyes saying, I know Grandma would have wanted me to do that. We talked about this all the time. And he's shaking his head. Yeah. Okay, Emily, I'm starting to run a little bit out of time, so I'm going to shut you off here and see what people have said. And of course, this is one of those that isn't right or wrong. But what I find interesting across the state is what parts of the state and communities say, oh, yeah, it's a good thing. I did that when I was between college and whatever. But I see this group, 40% of you are saying, no, you're not going to give Christopher the funds. Now, another way that we can look is a mandatory standard, and that's dictated in the trust document. You might say that you're going to do it by a certain age, or maybe life occurrence, like they graduate from college, when they get married, when they have their first child. Or you may say 25, 40, or whatever. You can also do intervals. They get some of it at 25, some of it at 30 and 35. You decide, it's your asset. So I've got a quick question for you here, and it's about what age? What age, if you had a trust, do you think is best for the distribution to your beneficiaries? Would that age be 22 to 25, 26 to 30, 31 to 40? How about 41 to 50, 51 to 60, or 61 and older? Now, you might think that's a funny question, but I actually had a lady come up at one of my programs and she said, guess when I get the trust assets? I said, I don't know. And she said 65. So I think there was a grandma that wanted to make sure that she learned the value of work, but also wasn't that interesting. Okay, what have we got here? Emily with our responses. Okay, looks like we've got, oops, I did the wrong, oh yeah, here we go. Most of you were saying 26 to 30. And that is a common response because that's when people start kind of settling down, buying a home, and people want to help with that. Okay, next. You can also do percentages when you have a trust rather than doing dollar amounts, and you'll find that the attorney wants you to do that. So I just have some examples in here where we're looking at 15% of this trust would go to big brothers and big sisters in Gallatin County. If you decide on a corporate trustee, do visit with them. I've discovered there's lots of variation in the corporate trustees that we have in Montana, whatever they cost, the minimum amounts, and it just depends on the assets in their trust. Many of them have said, we manage money. We'll do that. We're not going to run a ranch. We're not going to do an apartment building. They'll convert it to cash. So just ask. So you see, a testamentary trust can protect assets for minor children, those living with some form of dementia, and a financially incompetent heir. Now here we have the bitterroot, and all us Montanans know what that flower is. And what I want to do is have you, Emily, share about bitterness that could result from a lack of a trust in a remarriage situation.
Yeah, so I think you'll have to, perfect. So let's say we have an example. We have our husband, dad over here, had 2 kids with his former wife, but he remarried. And when he remarried, he replaced their house, or he placed their house in joint tenancy with his new wife. This isn't in a trust. They just have the deed under joint tenancy. So let's say that the husband passes away before the new wife, and so she is the surviving joint tenant. What happens is that she receives all of it because the home was in joint tenancy and not in the name of the trust. So then what happens is if the wife were to pass away, her children, so his stepchildren, would receive everything. So
Sorry, Emily, it looks like I'm missing a slide.
it's okay. So something that could have been done to avoid bitterness by the children from a prior marriage, because the way that things have worked out for this family, the husband's children from his first marriage have now received nothing. What they could have done was each parent place their property in sole ownership, so they would each have a portion of it. Each parent could then write a testamentary trust in the will. And the way this would work is that the testamentary trust would provide that if the husband passes away, the children would receive the land that was the husband's, but his new wife would still be able to live in that home for life. So those children from his previous marriage could not kick his wife out of the house after he passes away, but they would receive the land that was part of their father's estate. So then when the wife passes away, she no longer needs that house, of course. And so then his children would receive that home after the wife dies. So it's essentially a way to make sure that, that his new bride is taken care of, but that his children still receive the part of the estate that he intended for them. So just thinking about that, especially when we talked a couple weeks ago about joint tenancy and what that can mean, and the kind of problems that can cause, especially if it's doing something with our estate that we didn't intend it to. So trusts are an opportunity to protect assets for children, especially in a remarriage situation where those scenarios can be a little bit sticky.
Well, the observation for the Lady Slipper, Emily, is time has slipped away. I tell you, 30 minutes just goes really fast. And if you don't have a memory like this elephant's head, maybe some of you heard your grandma say that. Oh, you have a memory like an elephant. We have 44 different mock guides that are available to you. These are on the web. And so if you have access to a printer, you can print those out. And don't forget that these are also available from your local MSU County Extension Office or Reservation Office. The mock guide, one of the resources that we have is Revocable Living Trust. So if you go back and look at the resources for this session, that will be one that's there. We invite you to join us next week because we're going to be talking about gifting and what are some of the federal regulations about that and how can we do it in such a way it's beneficial to those that we are giving the gifts to. And we really do, again, appreciate your participation in our webinars. It's an opportunity for us to share this information that we couldn't have done, 20 years ago. Stop sharing.
So first question that came up, if I have stocks and bonds plus my Roth through DA Davidson with the beneficiary already in place, do I need anything else for that to happen when I'm gone?
No, you have already, and you are fortunate that you have one of those companies that did provide you with the opportunity to name a beneficiary. When this law was passed in Montana, we had some that were not allowing people to have benefit. I mean, go figure. And so Montana passed a law that said they have to offer, if they're going to do business in our state, a transfer on death registration. But you've already done that with your beneficiary thing. And so it allows those people to make the decision. Will they keep the stock or will they sell the stock at your death or at any point in time? So you're all set. And you'll avoid probate.
So this one isn't so much of a question, but maybe just some input. Someone said that they have a trust because they have no children and they want to use a corporate trustee to settle the estate. Do you have any thoughts or comments about that, Marcia?
Yeah, and certainly understand that. I've had several people contact me and they're just really in that situation where there isn't anybody that they trust enough to manage the assets that they've got. And, you may be stuck with the corporate trustee. I just make sure that they understand what the dollar amount of assets that you have. There are some trusts that were established that have such little amount in them that now the Attorney General in Montana has the authority, through the court system to even eliminate some of those, because what's happening is there's more fees being applied than for the amount that's there. And so so that's just something to be aware of. Make sure it's big enough that you don't have trouble with the corporate trustee.
Okay. Another thing that came up was just a clarification from that situation with the father with Alzheimer's and the mother and the son who doesn't get anything. Somebody said that they missed that the dad was still living. That 2003 that was listed above dad's name was the year he was diagnosed with Alzheimer's, right, Marcia? Not
yes,
he passed away. Yeah, just to clarify that for anybody else who had confusion there.
Yeah. Good catch there, whoever was noticing that.
Another question. How do I find a good attorney to help set up a trust, or is there someone other than an attorney that could help guide us in setting up a trust?
Okay, we do have individuals out there that maybe they're financial planners and they do sell trust, but they have an attorney that they're always working with. Because you see, a trust is a legal document and you want to make sure that it says exactly what you want it to say. Now, if you're hunting for an attorney, I sometimes use the term shopping. That's okay. We're trying to find the best one we can find. And I like to have an attorney that belongs to the business, estates, tax, trust, and real property section. And the short name of that is Better, BETTR. That's what they call themselves. And they attend continuing legal education programs sponsored through the state bar and even out of state. And so I want them to belong. The second thing I'm looking for is what percentage of their time do they spend on estate planning? You know, if you're in a bigger community, let's just say Billings, for example, there's a firm there that has, over 100 attorneys in their law firm. Well, they get to specialize. But if you're an attorney in Ekalaka, let's say, you have to do everything. Workers' comp, divorce, all those kinds of issues. But it's really nice if you can find somebody that loves estate planning and they really specialize in writing wills, etc. And now they tend to advertise a little bit. If you look in the phone book, and there was a time when they couldn't do that, but now they can say their practice is limited to, and they may say practice is limited to estate planning, wills, trusts, etc. So those are a couple of ideas. Belong to the Better group, and what percentage of their time is involved in estate planning.
Okay. Another question, I think we maybe already answered this, but just to clarify, does the Testamentary Trust help avoid probate issues then?
No, it doesn't, unfortunately. Now, let's say all of the items that you have, you do the POD or the TOD and it goes into the trust. Yes, those items will avoid the probate process. But if you have this will and it has the pour over part, but we also want to make sure that, hey, that will applies, the will would need to be probated. So then we would have an attorney handle that for us. And I would certainly ask about the hourly fee. We have a new law that says you can no longer charge a percentage of the estate. The charge has to be reasonable.
Okay.
I wish they'd have been a little more definitive on that one because I don't know what is reasonable for writing a will. Is it $100? Is it $300? Is it $800? But ask when you call and you say, I need to have a will written. You can say our family situation is fairly common, husband and wife and 2 kids, and we want to make sure that we've got guardianship and conservatorship. I think an attorney's done enough of those that he or she should be able to tell you, I charge X per hour, and most of the wills I do don't cost any more than X dollars.
Okay. Another question that came up, I'm still confused about how Medicaid long-term care application is affected by a trust. It hasn't happened for me yet with assisting with a Medicaid application, but it has been on my mind. Does it have to be claimed as a resource?
Okay, that is one of those misnomers, or I can't even say the right word, but people have the wrong information. Like the guy that was the disbarred attorney. He was telling all of these people, and they were revocable trusts. And you see, if it's revocable, it means you have control. And if you have control, that is a countable resource. So a revocable living trust, if you have all your assets in there, it is not going to make you eligible for Medicaid because you have to spend assets down to $2,000 to be eligible for Medicaid services. So a revocable living trust does not avoid this challenge that people have that don't have long-term care insurance. So we've got a Mont Guide, and that Mont Guide is called Medicaid and Long-Term Care Insurance. and we've got another one about long-term care and Medicaid. So those two resources would be good to take a run through so that you have a better understanding. What does Medicaid consider as accountable income and countable resources?
Okay. Quite a few questions still. This is a good one. So we have only one son and would like everything to go to him. Do we still need a trust, or in Montana would a will be sufficient?
Okay, you have a choice. You've got one son, and the state of Montana would leave it to that son anyway. So you might say, well, why would I need a will? Well, if you've got some grandchildren, do you have some personal items that you would like to go to other individuals? Well, in the will, you can have that separate listing, and you can name those things that have emotional value to you, and they could go to other individuals. You might consider a trust if there's a situation where your son would have any addiction problems, or maybe can't manage money. I don't want to pick on this poor little kid, but if you had those kinds of concerns, that's where a trust would benefit you. Because if you just leave a will and say you leave it all to him, he's got it and he can do whatever he wants to with it. So it's kind of how much control do you still want to try to exert over the behavior of the child, as far as the money can be used for this, but not for that. Okay.
Okay. Another question. What is the easiest way for all my belongings to go to friends once I'm gone, including a home and vehicles, and designate someone to make life-ending decisions for me if I'm incapacitated? Can that all be done in one fell swoop, or will I need many different directives and documents?
Okay. Number one, sometimes we do estate planning for while we're alive as well. So the healthcare power of attorney is something new that Extension has, and that would help you name somebody to make healthcare decisions for you. So that's a very important document. The financial power of attorney, let's just say you go out, you fall down and hit your head out here on a curb. Well, who is going to make those decisions if that should happen to you? That would be the advantage of having a financial power of attorney. So we've got a healthcare power, we've got a financial power, and then we can do those payable on death designations, transfer on death designations. And so if some of you are new to this particular session, we covered those in past sessions. So go back to that recording that we've got on payable on death and transfer on death information. And, I look at a will as just that backup so that you can have that separate listing of tangible personal property, and you can make sure who gets grandma's quilt, grandma Ray's opal ring, like I have, and all those items. It's not easy, but it does require several different documents: healthcare power, financial power, and your will.
Okay. Another question. So we have a First Interstate Bank as a corporate trustee to liquidate everything and all of it going to a charity. Then we don't have to change the trust when we change which charities get the money, just the letter to the BACF. Are they legally required to do what we designate once they have our money?
Yeah, if you have a corporate trustee and you have it in writing that you want, let's just say MSU extension to get all your money, and then you change your mind and you just write it on a scrap of paper, and now you're going to give it to the University of Montana. So we may have a little bit of a dilemma there with two charities saying, wait a minute, what was legal and what wasn't? So if you do change your mind about your beneficiaries, make sure that that change is listed in the will, or you've got a trust. So make sure that it's legally been done in that trust.
Okay, so then they would be legally required to do what they've designated.
Even if I think that's the dumbest charity in the world, if I'm the corporate trustee, I got to give it to them, the only unless that would be in there is if that charity was a fraud. Because if you specifically said charity and it turns out they're fraudulent, then no, we would go to your secondary beneficiaries should something like that happen.
Okay. Just a quick technical thing. Somebody said they joined a little bit late. Is there a way to view these online? I put in the chat room just now a link to get to the recorded sessions for this. If you just go to the Tuesday tips, if you type in Tuesday tips, estate planning, Montana, it'll take you right to the page. And there's a section that says webinar recordings. But we have some other more trust related questions too. So if a husband and wife have tenancy in common on shared property, and the husband wants to leave his portion to the children and leaves it in the trust, does the wife still have rights to half if she's married for more than 15 years due to spouse benefits?
Okay, because you said that this property is a tenancy in common, then it means that both of you own an undivided interest. Okay, and what you've got as a spouse is you already have 50% of what we would call the marital estate. So that gives him the ability then to take that share of the tenancy in common property and leave it to his children. So what that would mean then is those two children then own the property with the stepmom or this individual that's here. And then those two will need to negotiate how they're going to if it's a house, maybe what we would want to do is talk to that husband and say, are there other ways that you could leave something to your children and still provide some protection for the spouse? Do you want to have a big harangue with the kids trying to kick her out of the place? Because there's another alternative is you could leave a life estate. What he could do is, now this is not legal advice, this is just educational alternatives. What we could have is a life estate for that tenancy in common portion that he planned to leave to the kids, but she gets a life estate in that. So upon her death, then that home would go down to the children. So you can accomplish whatever you want. You just need to write down what's your objective, what do you want to accomplish, and then when you visit with the attorney, say, give me choices. What's a life estate and why is that advantageous or not? What's plan B? What's plan C? Because there's more than one way to often achieve your objective.
Okay. So then what if a property is in joint tenancy, but the husband has written it into the trust for it to go to his children? What would happen then if they've been married long enough?
Yeah. Okay, I'm sorry, I'm so eager to answer that one, because if you've got the property in joint tenancy with right of survivorship, it is not in the trust. Remember, if you have something in trust, it's going to have the name of the trust on it. So if you've got joint tenancy and one dies, it goes to this survivor. And this survivor can do whatever they want to do with the property. And you hope the survivor says, oh, she wanted to have it go into the trust, so yes, I'm going to do it. On the other hand, I might meet that good-looking guy down the road and decide I want to marry him and put it in joint tenancy with that individual. So it's just a way to protect your property. So take a look, first of all, and really know, is the property joint tenancy with right of survivorship, or is it in the name of the trust?
Okay. Another question, what are some disadvantages of a trust?
Okay, one disadvantage that I would see is the cost. I mean, most trusts run up in money. And now, again, it could be anywhere from $800 to one lady told me she had one for $5,000. And when I, talked to her further, it was a total estate plan, including business arrangements and some other kinds of things. But certainly the cost is a factor. And then you've got to go through and you can decide if it's a hassle or not, changing everything that you own that you want in the name of the trust. You've got to change all those titles, the deed, the checking account, the certificates of deposit. Don't forget the United States savings bonds. So that part is a concern. An advantage would be is a trust, testamentary trust, doesn't go through probate, and a will does. So technically, any Tom, Dick, and Harry can go to the clerk of the district court and say, I want to see what so-and-so said in their will. I don't know that that really happens that much, but it is another public record, and a trust isn't. Although I was in one community and I was having lunch and I was listening to the table next to me, and it turns out that one of the kids had been supposedly disinherited, and he was upset about this. So if you think a trust is totally secret, sometimes those beneficiaries talk about it and share it with their friends anyway.
Okay. My wife and I each have an AB trust, and assets are titles in the trusts. What about IRAs and 401ks, which only have the other spouse as beneficiaries? Will the retirement accounts eventually work their way into the trusts upon death?
See, I see no way how they would, unless you're going to have a will or you have pour over things into it. So if you've got that trust, you need to check with the attorney that wrote it and ask that question if you want those assets to go there. And there's many consequences right now, and there's changing laws about these individual retirement accounts and some of those issues, and whether or not an IRA is a person or a thing, and that makes a difference in how you want to have those taken out. So check with your attorney on that one.
Okay. Another question, would a revocable living trust be beneficial for land, home, and vehicle assets that cannot have beneficiary designations, but we want to keep the title in our name?
Well, why are we going to have a trust if we're not going to put the property in the name of the trust? I mean, we could have a testamentary one and say all of those assets go later. But if you want to keep control of it right now and you want it to go to a specific thing or person, you could have a transfer on death deed. We're calling it a TOD. So you've got this land out there, or you got a home, and you could do a transfer on death deed to a certain individual. So it's yours, you control it until you die. Your beneficiary can't have anything to do, they can't use it as collateral for a loan. They can't do anything with it. It's theirs, but only when you die. And if you change your mind, all you have to do is file another beneficiary deed. And you can put PODs on the checking and TODs on the stocks bonds. We don't have that ability yet with vehicles, but the motor vehicle department has a very, quotes, easy form for you, and we have it at the website to fill out if you own that jointly with another individual. So you got to be clear on what is it you're wanting to accomplish, and then which tools does the best job. And if you're cheap like I am, you want it to be the least expensive way. That's kind of what I'm after.
Okay. Another question came up. I recently inherited a property with home from my deceased fiance. He willed it solely to me. However, he wanted the home to stay in the family when I pass away. I have been paying all the taxes and soon insurance and will be renovating it. Any ideas as to pass this along? I'm not sure what the
Okay, if he left you the home and it is totally yours, were there any provisions in the will that you had to keep it in the family? Or was that a conversation that you and your fiance had? And I'm also sorry for the loss of fiance. That's tough. So it is yours. If there's nothing there that says it has to go on, and you're spending your money, you're paying off the mortgage, you're making it your place now. It's yours. And if there isn't that language in there, then you're the one that decides what to do with it. And you can make that decision through time. You can write a will. You can have the transfer on death deed to leave it to whomever you want to.
Okay. I'll keep an eye out for if there's any clarification that comes in for that question. Okay. So here's another one. We have a corporate trustee for our revocable living trust. Should our IRAs, etc., have as primary beneficiary the trust with no secondary beneficiary? Or should the primary beneficiary be the spouse with the trust as the secondary beneficiary?
Oh, That's a very good question and put in a very excellent way. And the issue there is because of these new things with the individual retirement accounts, I hesitate to say what is best over the other in that case, because it's always good to have successors. Okay, because you might name a beneficiary that dies at the same time you do, like in the same vehicle or for some other reason. So the one thing I can say for sure is go ahead and make sure you've got secondary beneficiaries. And if you have been working with an attorney on this trust, again, I would have that attorney take a look because of these new laws and say, what is the best for you now? Because we know if we leave it to the spouse has benefits that if you leave it to the grandchildren, they don't. For example, an IRA now has to be taken out in 10 years. Before, it was based on life expectancy. So if you had a grandchild that was 20 years old, he could take out 1/40th every year. Well, now he has to take it out in 10 years. So there's a lot of information out there about the impact of this new law. And I got to be honest and say, I haven't studied it enough to be definitive about an answer on that one. I'm sorry.
Okay. Another question, can you address the digital footprint of a trust, online accounts, etc.?
Emily, you're my techie. What's a digital footprint in your mind?
I think, and the person who asked this can clarify if I'm not representing your question correctly, but I think they're saying digital footprint usually refers to being able to track that information, right? Like everything you put online, somebody could find it if they're good enough at it. Is there any sort of those issues with a trust?
Maybe you're thinking of some of those trust things that you can do online. You can establish a trust online. You're entering all this information. And, supposedly there is protection for that. Certainly the attorneys that are developing trust and now doing so many things online are being really warned about how can you prevent this information from getting out, which at the same time makes me think of as something that we included in the mod guide is digital assets. Who's going to be able to get into your so much of it is done online now, and you've got a password on that. Well, how will your personal representative, how will your trustee be able to get into that kind of information? And I found out Montana has a law about that, and you can put something like that in your financial power of attorney or in your will. So that would be a new thing, and maybe Emily, another topic that we'd want to explore perhaps for next year about that.
Okay. Another question. In Tuesday Tips, are we ever going to talk about trusts that protect assets from creditors, or do all trusts do that?
Okay, probably what we're thinking about here is somebody that's in a nursing home. And there is the possibility to do an irrevocable trust. There are some attorneys out there that can do one of those, but you still have a 5-year look back period. It used to be 3. Everybody's been telling me a 7, but no, it's a 5-year look back period where they look and say, did you transfer any property to make yourself eligible for Medicaid? Because that's against the law to do so. But there are trusts. The thing about an irrevocable trust is it means you establish it, you put the assets in there, and you could never go back there and say, oh, but I'm sick, I need some of this money. Or, oh, one of my children is wanting to buy a house, I want some of this money. It's there and you can't grab it out. So before that's something you really want to visit with an attorney about, is one of these irrevocable trusts before you do it. There's a lot of them out there. I think of the Kennedys, the people, it's not going to matter, but you got to have some money to be able to say, I'm going to put all that over there. And then, gee, what if the kids don't take care of me like they said they were going to? So a concern. ask questions.
Who checks if the corporate trustee actually follows through on the wishes of the trust if there are no living heirs to watch that?
Okay. There is all of our corporate trustees are a part of the banking industry as well. And they have inspectors that go out and take a look at some of these kinds of things. The Federal Reserve also does that, just looking at dollars and cents and all that. And my sense is that although there's never, ever guarantees about it, I would feel pretty comfortable, because with a corporate trustee, there's always somebody above them to look into something. And even if one of your corporate trustees dies, there's going to be somebody else to take over. And if you have an ordinary trustee, that's why you would want to name a successor, because maybe the one you named first got Alzheimer's and can't do it anymore. So you would need to have that successor in there.
Okay. If a relative moves from another state to Montana, how long do they stay here before how long do they have to stay here before Montana law kicks in? I think they're referring to just a state law in general in Montana.
Yeah, and so you've moved to Montana. What they're going to look at is the definition of domiciled. Are you domiciled here? And so the way that you would prove that is you've got a driver's license. You have a place that is your home. You have electric bills. You have all of these kinds of things to show that you are a resident. Now, it may be different for, are you a resident for paying tuition purposes? Are you a resident for voting? So some of those may vary, but typically it's a 6-month type of thing. And if you moved here with a will from another state, as long as it was legal in that state, Montana has reciprocal agreements with the other states to say, as long as it was legal there, it's also legal here.
Okay. We got some clarification on that question about the house from the fiance. She said, my fiance would have liked his brothers, sisters, and my kids to inherit the property when I die. It seems like a huge problem. Can a trust designate that all must pay for the upkeep of the property?
Okay, so it says I just want to make sure I'm right on this. Are you saying then that the will is leaving it, or he said in the will he wants you to have it, but he wants you to leave it to these others? You know, was it a will that was written by an attorney, or was it a handwritten will? I tell you what, if you will email me, we can explore that one a little bit more, or call me at 406-600-7957, and we can get some of those issues worked out. Thank you.
Let's see, where was I at? Is it legal for a conservator to list themselves as a beneficiary to an incapacitated person's bonds?
Oh boy, that one I don't know. I would certainly look at it as a conflict of interest. What requirements did the court make when they issued the conservator? Let's check that one out a little bit further. It could be, it's like gifting. If you have a financial power of attorney, you can continue to gift just like mom used to do. And that might even be to yourself and to your kids, but it's also brothers and sisters and their kids. But with the conservator, I don't know under what conditions that conservatorship was established. And if you feel there's something going on there that might be financial abuse, we have the Adult Protective Services in Montana that will investigate those kinds of things before it becomes a big issue. So that might be one to check further with.
Okay. And if there are folks who have questions that you maybe want some follow-up on, you can certainly submit your email address in this chat. And like we mentioned earlier, nobody can see the chat except for Marcia and I. So we can certainly follow up with you later too, if you need. But another question, a special needs parent creates a will addressing a third-party trust funded upon the parent's death. Should something happen so the parents need to qualify? Should something happen so that the parent needs to qualify for Medicaid, can they still apply or are the funds taken?
Okay, when you establish the special needs trust, if it was done correctly, it was established for the benefit of the special needs child. And that trust is to provide additional resources to that child, but not keep the child from getting, being able to live in their, the home or group home, whatever it is. Now, for the parents, we look at what is it the parents own. And the parents don't own the special needs trust. They have a trustee that is a third party that controls that. So they can't yank money out of there for their own purposes. That's like even establishing under the Uniform Gifts to Minors Act, you open one of those accounts at a bank, you can't go back and say, oh, I need that money now. No, that was established for the child. So that should be protected.
Okay. Let's see, we've got another one that popped up.
We're setting a world record here for questions
I
today.
know, yeah, I kind of thought this one might be, oh, nope, we just have somebody who said thank you.
Okay, and I would encourage you, if you do put your email in, be careful that you do it correctly, because we've still got that one person that I emailed some information to and it bounced back. And don't have another way to get a hold of her and be able to answer that question. So second check when you're giving us your email. We'd appreciate it.
Yeah. Just a quick thing I put in the chat as well for those of you who are still on, the website link to the Tuesday Tips website, just the main front page. If you go there each week, it'll have a nice big button that you can just click to join the webinar. And that should alleviate any problems of needing to enter a password or anything, because those links just take you straight there and you can click on that from your phone or your computer. That Tuesday Tips website also has past recordings and resources like the Mont guides that Marcia's mentioned many times. And it also has a schedule for you to see the events that are coming up, so you can keep track of that as well. I think that's all the questions we have. We had a lot today, so I'm making sure that I got to all of them. But yes, I think that's what we have. And this should be posted by the end of the week as well. So if you want to review or you had to tune in late, you can go back and look at this. We usually have them up on the website by Friday. So
okay, well, thank you again for joining us. We like this, be able to share some information and to have so many participants. So we're delighted. So we look forward to seeing you next week at Tuesday Tips.
See you then.